Hello, my name is Kim Pott. I am the MBNA Executive Vice President. Welcome to today's webinar on copyright law in the monument industry. This webinar does offer one education credit for certified memorialists, so just a reminder there. And to help us have a great webinar, for those of you who haven't already, please mute yourself so that when you're not speaking, so that we can keep it nice and quiet for our speakers. And we will take questions at the end. So at the end, I'll give you some instructions on how to share your questions. We'll have an option for you to just chat them, or you can raise your hand. Without further delay, I'd like to introduce our speakers, Kevin Tharp and Jacqueline Flint with Riley Bennett and Egloff. Hopefully I said that right. Kevin is a construction attorney with extensive experience in intellectual property protection, and Jacqueline is an attorney representing and advising clients in a wide variety of legal matters, including business litigation, intellectual property, and contractual disputes. So right up this alley. Both have extensive experience with copyright issues in the monument industry, and authored a recent article in our July MB News magazine. So if you haven't read that, give that a look. So I will welcome Kevin and Jacqueline.
Thank you, Kim. As Kim mentioned, my name is Jacqueline Flint. I'm an attorney here in Indianapolis, and I've done quite a bit in the intellectual property space, particularly with copyright. So I'm happy to be here today, and this is my colleague Kevin Tharp. If you would like to say something about yourself.
Certainly. I've been practicing law for about 25 years here in Indianapolis. All of that time I've spent working on intellectual property matters, in addition to some other practice areas, including copyright. Copyright presents some interesting applications in the monument context, and we're happy to have the opportunity to discuss those with you here today.
Yeah. So we'll just jump right in. We want to make sure that we're using everybody's time well. So first question on your mind might be, what is a copyright? Well, a copyright is actually a constitutionally recognized property right in a original work of authorship that's fixed in a tangible medium. So this right is actually spelled out within the United States Constitution, within Article 1, Section 8, that provides that Congress shall have the power to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So this is really the founders' way of saying, we want our citizens to invent, we want them to be creative, and we want them to be able to own that right. And that's what copyright law is really about, is securing that right. The definition of copyright breaks down into 3 elements. First, a work must be original, and we'll talk more about what that means, but it must be an original piece, can't be a copy piece. Second, it must be a work of authorship, which means that it must be created by a human. And it must be actually created, not something AI generated or anything like that. And then third, it must be fixed in a tangible medium. So this means that it can't just be an idea or an oral transmission. It must be captured into either a digital or a physical form. With respect to the monument industry, this would mean that the monuments themselves, that would suffice as a tangible fixed medium, or even a drawing of a particular design, that would have a fixed tangible medium as well. The originality component of copyright is a pretty critical one. And I think it's probably the most important for the monument industry specifically, because there's a lot of pieces of monuments that carry over a lot of themes and ideas. So to qualify for being an original work subject to copyright protection, work must have a minimal level of originality. Can't be copied from a different work, can't be taken in portions of that work that's a copy of that. It must have a minimal creative spark to be considered original. So we wanted to provide a few examples of this for you. So the first picture, the far left photo, you can see is the old wooden cross, so to speak. It's essentially 2 pieces of wood, no writing on it, just 2 pieces of wood that are nailed together to serve as the monument there. As we progress down, you see that there's a little bit more creativity that's associated with the same concept of a cross in a monument. So the stone serving as an absence to create the cross. That would be a creative component of the same idea of the cross that you see in the first picture. Or to the far right, a more stylized version, you can see still the idea of a wooden cross that's maybe put into stone in a different color with quite a bit of stylization with the curvature surrounding it, the nameplate, all of those pieces, those would be the original components of that particular design. So hopefully that gives you a good idea of what we mean when we talk about originality and what we mean by needing that minimal level of creative spark. So with copyright ownership, that ownership right that we talked about that's constitutionally created vests immediately upon creation of the copyrightable work. You don't need to get a registration to have that ownership, but we'll talk about what the registration does. What you do need that for later. It is an immediate, as soon as it's created, there's an ownership right with your copyright. That copyright ownership is going to last for an individual. A known individual author, the copyright lasts for the life of that author plus 70 years. That number's changed some through the course of time. Some people call this the Walt Disney rule or the Mickey Mouse rule because the year dates have statutorily changed over many years based off of when that copyright for Mickey Mouse was going to expire, which recently did. Congress did not step up on that again. But so for the known author, it's the life of the author plus 70 years. For works where the author is not known, so an anonymous work, or a work that is contracted by an entity created for that entity specifically, so a work for hire, the copyright will last the earlier of either 95 years after the date it was first published, or 120 years after the date it was created. So again, if you decide to hold on to something and publish it 40 years later, the date that's going to be applicable here is the 120 years after creation, not the 95 years. It's going to be the earlier of those two dates. With the copyright, the owner of that copyright has a certain set, or as they taught us in law school, a bundle of sticks that serves as the exclusive rights that copyright owner holds for their copyright. First, they have the exclusive right to reproduce the copyrighted works. They have the exclusive right to prepare derivatives or branch off works from the original work. They have the exclusive right to distribute copies of the work to the public by sale or other transfer. So that would be the actual sale, for example, of a monument to a customer. That would be where that exclusive right comes in. Or the display or performance of copyrighted works publicly. Now, of course, nobody's probably performing a monument, but the display of a monument perhaps in your shop, that would be part of this particular set of rights. You would also have the right to license any of these exclusive rights to a third party, whether that be an exclusive license, meaning to the exclusion of everyone else, or non-exclusive where other people can do the same thing. But the copyright owner themselves have the ability to decide whether or not they want to make that license.
All right, it's my turn now to talk about question of copyright infringement. Jackie had been talking about copyright itself. What is it that the copyright protects? What rights does copyright give to the copyright holder? And I will be talking about what infringement means, what the copyright holder's rights are when somebody else has infringed upon the copyright. Generally speaking, someone has infringed a copyright when that person has violated one of the exclusive rights of copyright ownership. In the monument industry, that's most likely to be violating the exclusive right to reproduce the copyrighted monument or to distribute copies of that monument. Obviously, most of us here are in the business of making money, selling monuments, creating monuments. So it's that ability to copy that and then distribute those copies and sell those that is of critical importance to you. The burden in court is upon the copyright owner to prove infringement, and most specifically, I'm coming back to this word again because in the context of the monument industry, this is very important. The burden is on the copyright holder to prove that the accused infringer copied original elements of the subject copyrighted work. There are two types of evidence that a copyright holder can rely upon to prove that there has been copying and infringement of the copyright. The first is actual evidence, which is incredibly rare. That would require, most commonly, either somebody who witnessed the actual copying take place, or if, for example, there were video of the actual copying take place. As you might expect, there's not a lot of that type of evidence that's around. And so most commonly, copyright holders rely on circumstantial evidence to establish that copyright infringement. And that circumstantial evidence comes in two components. The first is the copyright holder has to prove that the accused infringer had access to the copyrighted work. That typically requires that there be actual evidence of access, and that not be a product of speculation or conjecture based solely on the fact that the two articles, the copyrighted work and the accused infringing article, are very similar. You can't infer from that that the person who created the alleged or accused infringing work had access to the copyrighted work before they created the accused work. So there has to be some other indication indicating that they had access to it in order to be able to prove the element of access. The second element that's required to prove infringement by circumstantial evidence is a substantial similarity between the original elements of the copyrighted work and the allegedly infringing work. And as you might expect, determining whether that substantial similarity exists in a particular case is highly fact sensitive. It very much depends on, in the context of the monument industry, what do the two monuments look like? What are the elements of the copyrighted work, and how do they differ? Not just how do they differ from the accused work, but what is the nature of those elements that the copyright holder is seeking to protect? And we're going to talk about that here in just a second. So one of the things that's a challenge in the monument industry is because there are so many designs out there, right, for monuments. Just in the cemetery, the gravestone, the headstone context alone, there are countless numbers of designs. And some of them share similarities and some of them are very different. And they incorporate a number of different elements. Some of them are very common, like a cross, for example. Other elements are unique to that particular person who's deceased and whose loved ones or want to use that design or what have you that's specific to this person to commemorate them, to remember them. And so it's important in the monument context that we go through when we determine when there's been an accusation of copyright infringement, that we go through and we look element by element, comparing first the copyrighted work to see what in fact the elements are there, what are the design features that the copyright holder is seeking to protect, and then comparing that to the infringed work to see how many of those elements are in the infringed work and which elements are in the infringed work. Are they in fact original elements, or are they the elements that are in the public domain? The case that we have cited up here on the screen, the Arnie versus Sony picture television case, we've chosen this case to talk about in more depth today because this case really, in this case, the court really went to lengths to emphasize the importance of dissecting the copyrighted work into its component elements, if you will, and then evaluating which of those elements were original and which were protectable compared to those that were not. The very quick backstory on this case is that the photo on the left here with the tree and the church in the background was taken by a gentleman in Boston, Massachusetts, I believe in the late 2000s, of a man who at the time was giving everyone the impression that he was a member of the Rockefeller family, Clark Rockefeller. And come to find out after this picture was taken, we'll talk a little bit more about the circumstances here in a minute, he was not Clark Rockefeller. In fact, he was an imposter who later abducted this little girl. And it was quite a story. There was a lot of attention paid to it. In fact, the story was such a big deal that Sony made a movie about it. And as part of that movie, in some sense, recreated the photograph on the left, using the photograph on the right. And the photographer of the original photo, Mr. Harney, was unhappy that Sony had, in some sense, recreated his photo in this way and sued Sony for copyright infringement. And so the question that the court was presented in this case was this in fact copyright infringement? And in the process of determining that or deciding that question, which by the way, the court said, no, there was no copyright infringement, made that determination short of a trial. So it wasn't that this question was submitted to a jury and the jury determined that there was no infringement. The court said, no, this is an obvious enough case that we don't need a jury to tell us that there's no infringement here. We can just, the judge can just decide this on his or her own before a trial. And so in that process, the court issued a written opinion describing the court's reasons for that. And so we're going to chat with you briefly about those. So looking at the photo on the left, which again was the original copyrighted work that the photographer was seeking to protect. And then looking at the photo on the right, you'll see that at first glance, there are a number of similarities. There's a blonde girl riding on the shoulders of a man with red hair, a man with a prominent nose. The girl's jacket, the slightly different color, is kind of the same type. And so it's obvious that there are similarities between these two photos. So what was it that led the court to ultimately conclude that there was no copyright infringement as a matter of law? Meaning it was an obvious case that there was no infringement. So when the court went through the process of this analysis, the court began by identifying what the elements were of the photograph on the left. And the court said, here we find are the following elements. Number one, there's a girl riding on the shoulders of a man, and they're both holding elements that indicate that this was Palm Sunday, which was the day that this photograph was taken, of a church on the Beacon Hill neighborhood of Boston. The court also noted that how this photo was framed and the background with the tree and with the church also were protectable elements. The fact that the photographer decided to include those in the background was that decision was entitled to protection as under copyright law because there was an element of originality to that. And in addition, the court said that the lighting in this photograph was also entitled to protection as a matter of originality, and specifically the fact that there were shadows that were falling across the two folks in the picture, that the lighting and the shadows were an element that had originality to it and was entitled to protection. The court then turned to the photograph on the right and said, okay, what are the same element, or what elements do they have in common? And the court said, well, really the only thing that they have in common is that the little girl is on the shoulders of the gentleman. Yes, their clothes look somewhat similar, but they're not identical. So what they really have in common is this pose. And the court said that all by itself, coupled with the fact that they're both in both pictures, the two of them are in the center of the photo, is not enough to create an issue that should be sent to a jury to determine whether this was copyright infringement or not. And the court basically said that this pose all by itself was not, it didn't have an element of originality to it. It's not something that originated with this photographer. And another thing that the court referenced, which I think is important to the extent that it distinguishes this scenario from what we see in the monument industry, is that in this case, in the photo on the left, the photographer did not pose these photos. He just happened to stumble upon them, if you will. He encountered them on the street. And so he wasn't the one who decided to put the little girl on the man's shoulder. She was already there. To the extent that the photographer had any decision-making, if you will, into how this photograph was taken, he chose the background, with them, being in front of the church and in front of the tree. And he chose the lighting in terms of how the individuals were oriented towards the sun, but he didn't choose how the two folks were posed. In citing the differences, the court noted the substantial differences in the background, right? And the photo on the right, there's no tree, at least you can't see the trunk of the tree. You can't see the church. And unlike the lighting in the photo on the left, where there are shadows, in the photo on the right, it was very washed out. There are no shadows. And the court made a big deal about this in saying, look, to the extent that there was originality here, it was in the lighting and in the framing and in the background, and none of those three things are present here. And so for that reason, we're going to conclude that there is no infringement here. I don't know about you. I am not a photographer. I am not an artist. And so things like lighting and background are not things that just automatically jump out at me as something that's being significant. The fact that the court went to that level of detail in analyzing these photos really emphasizes the importance of identifying what elements are in fact trying to be protected here by the copyright holder, and whether those elements are in the accused work compared to other elements that are not subject to copyright protection. So it's just interesting, I thought, that this case, because as I said at the outset, when you first look at these photos, you think, oh yeah, there's quite a bit of similarity here. And in fact, that's the reason why Sony created the photo on the right, was because it was reminiscent of the photo on the left that had been made, that had been displayed publicly in the media and had been associated with this particular case. But despite the fact that Sony couldn't deny that the photo on the left was in some sense the inspiration for the photo on the right, the court still said, no, there's no infringement here. There's no substantial similarity here with respect to the original elements that could be protected by copyright. To give you a quick overview of copyright infringement litigation, an important point is that, although as Jackie mentioned, under copyright law, the copyright protection affixes to the work the minute that it is created. So in other words, if you're writing a book, the minute you stop writing the book, copyright protection affixes to it. It is protected by copyright. Whether you make copies of it or not, whether you do anything with it or not, it is protected by copyright. Having said that, it's not worth very much because until you take the additional step of registering your work with the Copyright Office, which is an arm of the Library of Congress in Washington, D.C., you're not going to be able to go to court to enforce your copyright. Keep in mind that all of the litigation that happens in copyright is federal court litigation. You can't go to your local state courthouse and file a copyright infringement action because all of copyright law is federal law. And so you have to go to federal court in order to file a lawsuit to protect your copyright. And you can't do that until you can show the court that you have obtained a registration of that copyright. So talking very briefly about the registration process, I think it's important to distinguish that registration process from a trademark registration process, trademark being a logo or slogan or some other indication of what the source of a product or a service is that's being sold in commerce, like Coca-Cola, like Riley Benedict Loth. Compare that to a patent, which is for the patent office, in which you are in some sense trying to obtain the exclusive right to exploit an idea that you have for a product or to improve a product. The reason why I mention that is those three in that order, the office that is registering those types of intellectual property go to increasing efforts to try to confirm that you in fact have the exclusive right to do this. If you going in reverse order, starting with the patent process, the patent, as you may know, patent filing fees are very high by comparison. And that's a reflective of the fact that the patent office is actually going to go to quite some length to confirm that the invention that you're claiming has not been invented by somebody else and that you are in fact entitled to do that. And that's an extensive process. It takes quite a bit of time.
And technicality.
And technicalities. Trademarks are kind of in the middle. The filing fees aren't quite as high as they are for patents. And it's not that the trademark office is going to do an exhaustive search of everything in the world to determine whether you have the exclusive right to use this, but they are going to do a search of the existing trademark database of registered marks to confirm that there's nobody else who's registered that mark has an active registration for the same goods and services in the same market. On the other end of the spectrum is copyright. And the good news is in a copyright registration, the filing fee is very low. I think it's 35 or 50 bucks, as I recall. And the examination process in the Copyright Office is pretty short. The short answer is they're not going to go to really any length to examine the work that you're depositing with your registration to confirm whether there's anything else like it that the copyright's already been registered. They're going to look at your application. They're going to check the box to make sure that you've filled out everything that you need to fill out, that you've submitted everything that you need to submit, and then they're going to register it. And that's it. It could very well be that there are all kinds of things that are registered with the Copyright Office that in some sense infringe upon one another. The Copyright Office isn't engaged in that analysis in any meaningful way. So for that reason, it's important that if either you are asserting a claim for copyright infringement or you have been accused of selling monuments that infringe somebody else's copyright, that you go through or your attorney goes through the analysis to determine whether in fact there is anything in that copyright, the registered copyrighted work that is an original element that is subject to protection. Because just because they have a copyright registration doesn't mean that there is anything in there that is subject to copyright protection. And it will be, if infringement litigation ensues in court, it will be the court will be tasked with determining whether in fact there is anything in the registered work that is original and that is eligible for copyright protection. So it's important that you understand that in order to get through the federal courthouse door in a copyright infringement claim, the one who's holding the copyright needs to have registered it. But just because they have the registration doesn't mean that they've got a lay down case against you by any stretch of the imagination. The fight has basically just begun in terms of determining whether the work that is subject to the copyright registration actually is protectable under copyright law. So once the plaintiff has proven their case that there is in fact copyright infringement, what remedies are available potentially to address the infringement? Well, the two big ones are monetary damages and injunctive relief. Monetary damages are just exactly what the name suggests, that after conducting a hearing, a trial or so forth, the court will determine what an appropriate amount of money is for the infringer to pay the copyright holder to remedy the infringement. There are two categories of monetary damages. The first is actual damages. These are damages that the copyright holder can prove by virtue of the infringement. This is not always easy to prove, and the damages that the copyright holder can actually prove are often relatively small. And so because of that, and because Congress wanted to create a meaningful remedy for copyright infringement, Congress came up with what's called statutory damages. And this is actually a range of damages that are provided in the Copyright Act that a court has discretion to choose, but among those in that range of damages for each act of infringement, depending on various factors. How severe or serious the infringement was, or is this kind of a technical case of copyright infringement, for example? Or are there other circumstances that might demonstrate that not only was there infringement, but the person who did the infringing did so willfully, often because of some personal animosity or relationship between the copyright holder and the accused infringer that led to, or was behind, if you will, the willful infringement. The statutory damages typically are capped at $30,000. They can be substantially less than that. And that doesn't necessarily correlate. The number that the court picks doesn't necessarily correlate to any actual damages that the plaintiff suffered. It's just simply there that the court can use to give the plaintiff some meaningful remedy when otherwise, a few dollars or a couple $100 in addition to the filing fee for federal court, it doesn't really provide much of a remedy. If willful infringement is found, then the statutory damage range increases to up to $150,000. That's pretty rare. That doesn't happen all of the time. That's a pretty unusual case to get a number that's that high, but it's out there and it's something to think about. On the other hand, if the defendant who has been determined to have infringed can prove that they did not willfully infringe and that they didn't have any idea that they were infringing a copyright, that can cause the range of statutory damages to be dropped to as low as $200. So that shows that Congress's intent was not to use statutory damages as just a club against defendants, but that if defendants can show their good faith, that the range of statutory damages can be adjusted down accordingly. The second component, in addition to monetary damages, is injunctive relief. This is where a court issues an order that either compels a defendant to do something other than pay money, or prevents a defendant from doing something. And in the case of copyright infringement, that injunctive relief is almost certainly in the negative, meaning court says, defendant, you've been you've been determined to infringe somebody else's copyright, you can no longer make copies of this particular work. And you must throw away or give to the plaintiff all of the infringing articles that you have in your possession. And sometimes that is as powerful a deterrent as the money damages are, and also sets up a situation where if it makes sense under the particular circumstances, perhaps that injunction is going to stay in place until the plaintiff agrees to give a license to the defendant for their use. And under that license, the defendant will pay the plaintiff something for the right to continue making copies of that article. The last consideration is the recovery of attorney's fees and costs. And this is an important consideration, not just in copyright infringement litigation, but really in any litigation. Because it's one thing to have a legal right, say, yes, I've been, whether it's a breach of contract or a tort, or you've been injured in a car accident or what have you, or you've been a victim of intellectual property infringement in some way. It's one thing to have that right. So that one thing, it's one thing to have a good case that you can be able to prove in court, but it has to make economic sense for you to actually pursue the case. And generally speaking, in America, the rule is that absent either a contract or a statute that gives you the right to recover your attorney's fees, each party to a lawsuit bears their own attorney's fees. And as you might expect, in litigation, the attorney's fees, particularly if you're paying an attorney on an hourly basis, can be really expensive, really fast. And so unless you have just a great case of copyright infringement, and there have been many articles that have been created that infringe upon that copyright, it may not make economic sense for you to pursue that claim unless you can recover your attorney's fees and costs from the defendant. And copyright is kind of a unique animal. I won't say unique, but it's a little different in the sense that the Copyright Act, as a statute, allows the plaintiff in a successful plaintiff in a copyright infringement action to recover their attorney's fees, but it's not required in the garden variety case. So the court has discretion to determine whether a successful plaintiff will recover their attorney's fees. That uncertainty about whether attorney's fees will be recovered is a big consideration for plaintiffs to think about before they bring a copyright infringement case, particularly if, in the case that we were talking about, the Harney versus Sony Pictures case. I don't know anything about Mr. Harney. I do know the name Sony. They do have a lot of money to throw at lawyers, and they can make the case that the prosecution of that case very expensive for Mr. Harney, unless he also is very wealthy. So that's something to consider as well in copyright infringement litigation, is to what extent will the plaintiff be entitled to recover their attorney's fees. And in a case where perhaps there's only one article, there's only one copy that's been made, one monument, is the likelihood of damages that the plaintiff is going to recover for that one copy or two copies or three copies, which is going to be a relatively small amount of money in the grand scheme of copyright litigation. Does that justify filing the lawsuit and potentially incurring those attorney's fees when the prospect of recovering those attorney's fees as part of the judgment, if you win, is uncertain? So that, in a nutshell, is copyright as it applies to the monument industry. We've got a few minutes left here, and we're happy to take any questions that you may have.
Yeah, so if you want to jump in with a question, if you want to click the heart react button at the bottom, you can click the raise hand or just unmute and shout out your question or put it in the chat and I can read it. Any questions?
Hey, Kim, I'll ask one.
Sure.
In one of the first slides, you had a monument that had a cross cut out in the center. And I'll use that as an example. Say there are, I know of 3 others of those, or say I know of 100 of those that are in, various cemeteries. How do you determine if there's a copyright and who owns the copyright, or is there one? Can someone go and register that copyright if there are multiple others out there, or do they have to prove they created the first version?
Sure.
Okay, good question, Mark. There's actually a couple of different questions there, and I will do what I can to break that down. So one of your questions was, could anybody register the copyright if there were, for example, let's clarify this. Let's assume that there are 100 of substantially the same design. For example, the one that was in the middle in our slide that has the cross essentially cut out of the stone, so it's kind of like a shadow or a relief, what have you. Let's assume that there are 100 of those out there that are just exactly the same. They're all identical. Somebody could, and I'm going to put could in quotation marks here because there's a big caveat, attempt to register the copyright in that. Any one of those 100 owners of that could. If they do that, they're perjuring themselves almost certainly on the copyright application, because unless they were the one who came up with that in the first instance, who created that design, they were not the author of that. Now, I say could because if you get past the part where you're perjuring yourself and all the things that happen with that, lying to the federal government, the Copyright Office is, like I said, probably not going to investigate to determine whether in fact you are the owner of it. They're going to, or the author of it. They're just going to rely on your sworn statement that you were the author of that. So in that sense, yes, you could understand that the minute you then try to enforce that copyright registration against somebody else, they're going to dig. They're probably not, if there's somebody who has any experience in the monument industry whatsoever, they're going to say, well, wait a second. This was registered, for example, pick a date, 2018. Well, I remember seeing this design out there way before 2018. Now, I couldn't tell you where it came from or who originally produced it, but it's those questions that are going to cause somebody who's been accused of copyright infringement to dig deeper and start asking questions around the industry. And with the benefit of litigation discovery, if it goes to a lawsuit, they can get information from various sources to try to figure out who was in fact the original creator of this, or at a minimum to say, well, we don't know exactly who was, we just know it wasn't you, Mr. Registration Holder. For all of these reasons, you couldn't possibly have been that person. So the other question, I can't remember if you asked this one or not, but it was one that popped into my head earlier. And that is with respect to those 3 crosses, the 3 monuments that we had, that each of them had the crosses. At what point in the process do those become substantially similar or different enough that either they have originality on their own, such that they could be copyrighted, even though they incorporate a cross that, if anybody, you don't have to be a Christian to understand what the symbolism of that is and how long that has been out there. To what extent does that, can somebody claim that they have, that the cross is a protectable interest? Or can somebody then use that cross in a different way that creates its own originality, that it's its own creative spark, if you will? The answer is, as you look at those 3 slides, again, going from left to right on the screen, the wooden cross that's basically just, somebody cut down a tree and and, created those two pieces of wood and put them together. The one in the center that has the cross with that's kind of the shadow, if you will, it's the missing cross, and then the third one that has the stylized cross over to the left, and it has different colors on it and so forth. My opinion as a copyright lawyer is that all three of those are sufficiently original, that whoever it was that could somehow pretend to claim that they had the copyright in the original cross design, even if they still had that right, and they don't, it's in the public domain, but even if they did, I would say that each of those three is sufficiently different from one another and have sufficiently different sufficient creative spark on their own, that it's original to them and would probably not constitute infringement of the original cross copyright, assuming that it was still in effect and still recognized.
Right.
Yeah.
I'll just add two additions to that too. What we didn't mention in the slide, but is an important element of this, in any copyright infringement case that you would have, the first thing before you would even get to whether or not there was an infringement, you would have to, the owner of that copyright or the purported owner would need to show that they in fact own a valid registration in that copyright before they can proceed with the rest of the analysis that we discussed. So that's step one, to Kevin's point of, is it a valid ownership? Is it a valid registration? The odds are in that case probably not. It's also worth noting that because of the instantaneous ownership right that's associated with copyrights, there is in fact only one owner of a copyright upon creation of an original work. So everyone else would essentially be a copy of that original work. There's only one owner that would have the ability to actually bring an infringement suit. Whether or not it's the person that's actually bringing that suit, that's a different question. But in the instance of somebody takes the idea and it's 4 generations down, it's unlikely that that person would be the proper owner in that context.
Yeah, that's great. Thank you. We've got some other excellent questions here, so I'll go through those. Are cemetery memorials monuments considered public art, and does that affect copyright possibilities?
Yes, they are in some sense public art. The fact that the monuments are in a cemetery doesn't really change that. The concept doesn't change whether it's on a street corner versus on a cemetery. But what doesn't change is the application of the exclusive rights in copyright that go beyond just displaying it. So when I think of, when I think of, a monument in the context of a cemetery, obviously someone purchased that monument and either they specified the design or they just saw one in a catalog that they liked and said, hey, I want that one, and please put my loved one's name on it. Understand that when that order is placed, particularly if it's coming out of a catalog and that copy is created, that potentially infringes someone's exclusive right in the copyright. Just the act of placing the order and obtaining the manufacture of another stone. You then take it and then display it, and that may separately be an act of infringement because you now are displaying what has been copyrighted by somebody else. But the key component there is the actual copying in the first place. That's what the copyright holder is going to be focused on primarily, and not so much on the public display of it.
Right, and I'll also add that in copyright law, and I won't dive too deeply, I'll just give a broad overview, there is a concept called the first sale doctrine, which in essence is when a copyright, when it's in a tangible form, so in this instance, a monument, when the monument is created and it's sold to a user, that user then is able to utilize that copyright. They have the ability to do that in whatever context they would like to do. So in this particular instance, when a monument is sold, the customer who is purchasing that monument has the ability to then utilize that monument as they see fit, and in this particular case, placing that to mark the gravesite of a loved one.
And it's important to remember that in that context, what Jackie's talking about is a lawful sale. In other words, it's not an infringing a sale. For example, say the customer buys the monument from the copyright holder. Once that purchase occurs under the first sale doctrine, that the owner or the purchaser of that monument can then do whatever they want with that monument, including, this would be odd, but potentially reselling it. If you're a consumer, I don't know that there's a lot of consumers out there, end use consumers reselling monuments, but they could do that. The most common example of that would be a book. You know, you buy a book, you have the right to then do with that book whatever you want. You can sell it, you can give it away, you can throw it away, and you don't have to worry about infringing anybody's copyright at that point with respect to that one article that you lawfully purchased.
Yeah, great. To what extent can you use emblems like college logos, TV movie characters, poems, etc. when designing monuments, particularly at the specific request of a family? That's more licensing. Yeah.
This gets a little bit tricky because of the various trademarks, copyrights that other users might have. So if that were to take place, if somebody were to request, for example, I'm a Purdue grad, so I'll just use Purdue as an example. Somebody wanted to use the slant P on a gravesite, that would require, that's a trademark of Purdue University. That would require a license from Purdue University before you can lawfully put that onto another design. So you would need to seek permission from the owner of the intellectual property that's at issue to be able to do that. And then once that you have the license to incorporate that into the design itself would be a separate copyright.
And that's all valid, and that's true. And if Purdue wanted to assert that right, they certainly could. My experience, generally speaking, has been that folks like Purdue, IU, other colleges are very reluctant to make an issue of that, because they know that what puts money in their pockets from an athletic standpoint is fan interest. And if somebody is such a Purdue or IU fan that they want to put the logo on their headstone, that if IU or that Purdue tried to stop that or really wanted to try to bring legal action on that, they're in some sense strangling the golden goose. And they don't want to do that. In fact, I think I've seen letters where schools have cautioned manufacturers about doing that type of thing, but then they say, but we certainly appreciate the loved ones, supportive. So there's the legalities, and then there's also the practicalities of it from a business standpoint.
Sure. Are there tools Oh,
I'm sorry, I can't see the button to push.
That's okay. Go ahead.
Go ahead and
ask your question.
Yeah, I want to give a scenario, and if you'll tell me who the bad guys are. How about that? The first off, the cross in your sample, the third one I own the copyright to, so good choice. That's a good one to use for our discussion. So let's say that design is used without our permission from a company out of China or India. Let's say India, who has a distributor in the US, and I use my design, I draw it for a family. They take it to a local monument company who buys that from a distributor in the US. So I can't sue anybody in India. Is the family the bad actor because they took my drawing to a monument company? Is a monument company a bad actor, or do they not know better if they didn't see the drawing? Or is a distributor who's distributing out of India the bad actor? Who do we go get for taking our design?
That is a very good question.
Thank you.
The answer is in that scenario, the real bad guy, as you suspect, is in China or in India. They're the one who actually made it. And we'll just say, without any regard to whether there might be copyright there or not. It's hard to characterize the family as the bad guy here, only because they're mourning. And all they care about is trying to commemorate their loved one in a way that they think will be meaningful, not only to them, but to the loved one. If they could, if the loved one were alive to see this. In the eyes of the law, they have culpability because they started the process. They provided the design. But again, it's hard to call them the bad guy under the circumstances. Assuming that there is infringement, the distributor also would have some culpability because they are in possession of an infringing article, even though the infringement occurred overseas. The infringing article is in their possession in the United States. And they then sold that to somebody else, which is a violation of the exclusive right. So the answer to your question is you can only go after those folks who are here in the United States. But again, my answer to that question assumes that there is infringement in the first place. It's just a question of who could potentially be held liable for it.
Right, and the classic answer for you is it depends. All of these questions, they're highly fact sensitive in the grand scheme, right? So the scenario you played out had several different steps to it. Each case is going to have its own individual set of circumstances that need to be evaluated. So it's hard for us to answer in a general way who might be a culpable party, or if there's a culpable party at all. That's the other possibility with this too. So I hate to do that, but I'm going to give you the very stereotypical lawyer answer of it depends.
And
that's how you make money, so I understand. It depends on how lawyers make money, so that's fine.
But to piggyback on that, to change your facts, suppose instead of the family bringing the design to, suppose they pull it out of a catalog, right? And they just say, hey, I see this design and I really like it. Again, speaking very generally, if I'm in that situation as a consumer, I'm going to assume that if I've been presented with a catalog, that the person who presents it to me has the right to sell what it is that they're selling. And I am not going to go, even if I'm a sophisticated copyright lawyer, I'm not going to go to the trouble of looking to see whether that design is in fact copyrighted somewhere. And so that's an example to support Jackie's generalization of it depends. You change that fact, that really changes who, both as a matter of law and as a copyright holder who's interested in trying to do the right thing, who you want to go after under those circumstances, because the circumstances are different.
Right. It would also be another distinction within that would be, was there any level of design change that occurred? And if so, what were those design changes? That kind of comes back to the substantial similarity question that we were touching on before.
Right. It's one thing to say, hey, yeah, there's some similarities, but there are also some important differences. I mean, then you start, you put that in front of a judge or a jury, and they say, okay, you decide to what extent, what did they copy Paul's design, or were they just merely inspired by Paul's design, but they created it on their own.
Mm-hmm. Yeah, I have two more questions I wanted to get to before we wrap up here in just a minute here. Are there tools that you can run pictures through to determine if there's a copyright? I think we talked about this a little bit. I don't think there's anything quite that sophisticated beyond going to the Copyright Office and just looking at the pictures.
There isn't presently, but with artificial intelligence, I wouldn't be surprised that it's coming, because you would need something that is capable of processing huge amounts of data to be able to go through the entire register of copyrights in order to accurately and thoroughly make that determination.
And then what is the vulnerability of a retailer who's unwittingly purchased a stock item from a supplier that is later found to be a violation of copyright?
I think that kind of goes back to the conversation we were having with Paul's question a bit, is it might be a stock suppliers, particularly that seems to be an instance where that happens a lot with international entities, which there is international copyright law that if you wanted to invest the resources to go hunt those people down, you could. I don't know how fruitful that would really be for you. But oftentimes it will land into those sorts of categories of, yes, there's probably a bad actor that did this, and then there are unknowing and unwitting people that are subjected to that after the fact based off of their acts. But what is it going to take to go get the actual bad actor? That's a different question entirely that's going to take its own practical evaluation.
And understand too, that the circumstances that were just described, Kim, if infringement is determined, the court is going to take those circumstances into account in determining what the remedy is. If they were unwitting, and if they only, for example, did it once or twice, then the exposure of that person is going to be relatively small.
Mhm.
We're talking like hundreds of bucks, maybe a few $1,000. Obviously, nobody wants to pay that, but it's not going to be crushing liability. If, on the other hand, they sold thousands of these, then at that point, just because of the volume, then you're looking at dollars that could potentially be significant, that if they didn't put somebody out of business, it would hurt really bad.
Right.
And so I guess that's another one of the take-home messages for this is the law is not just like a brainless algorithm. It just doesn't say, oh, well, you were under these circumstances, you unwittingly sold something that you didn't create, but it turns out it infringed somebody else's copyright. You sold one, you don't get the death penalty for that. But if you change the circumstances, let's say you wittingly did it and you just didn't care and you did it a lot, then the penalty or damages that you get stuck with are going to be a whole heck of a lot bigger under those circumstances.
Sure.
And I'll just add one last bit to that. I think this goes back to the elements we talked about with copyright infringement, of the first one being access. So if there's a lack of access to the original work, that's going to be a very difficult element for you to prove in order to be able to establish your claim of copyright infringement to get to a damage component.
Sure.
Yep.
Well, thank you so much, Kevin and Jacqueline. You've given us so much to think about today. I appreciate everyone else for being here. A reminder, you do get 1 hour of CM credit if you are tracking that. You'll get a survey at the end of when you close out of the session. A survey will pop up, so we would really appreciate your feedback. And we look forward to seeing you on future MBNA webinars. Thank you, everyone, and have a wonderful afternoon.
Thank you all.
Thank you.